We have major breaking news. The United States Supreme Court has just set conference dates to determine whether or not they're going to hear some major Second Amendment cases. They're going to conference some of the cases this coming Friday. That's tomorrow. And then some other cases a week from Friday. We're going to break down these cases and discuss which ones may be granted C, which ones may be delayed, and which ones may be just outright denied. We're going to break down these Second Amendment cases and discuss whether this overall Supreme Court term can be considered a blockbuster term or not when we come right back. Hey folks, I'm Mark Smith, host of the 4 Box of Donor, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say the top voice the Second Amendment in America, thanks to the 2025 Gundy's Awards, which leads us to, of course, I've been nominated again for the 2026 Gundy's Awards to be the top voice of the Second Amendment America, the top voice of the 2A. So, if you're voting for the Gundy Awards this year, please vote every day for Mark Smith and the 4 Box of Donna. I truly would appreciate your support. Stiff competition out there, but I think we can win yet again. Let's see if we can repeat, folks, and win for the geeks. All right, folks, we have to now talk about where we are with the U.S. Supreme Court. Just to jog your memory, the Supreme Court has already granted CERT, which means they're going to hear on the merits 2 Second Amendment cases. The first case we are going to win, that is the Woolford versus Hawaii case, arising from the U.S. Court of Appeals from the 9th Circuit out there in Hawaii, in San Francisco, California, and the like. This is a question of whether or not the so-called vampire rule is constitutional. This is essentially a property rights default rule that says that under Hawaii law, a concealed carry holder, even with a license, may not enter onto private property that is open to the public without getting express permission from the owner or the manager of that property. So, if you take a concealed carry permit holder in Hawaii and you want to go into a convenience store, a grocery store, a gas station, a rest stop, whatever, you cannot carry your gun into that location even though it's otherwise open to the public unless you get permission specifically from the owner. And who knows who the owners are of random gas stations on the highway? That is the Woolford case. The Supreme Court's going to hear in that case, and they're going to rule in favor of the Second Amendment. The other case, of course, is the Hamani case, United States versus Hamani case, dealing with a prohibited person statute, 18 U.S.C. 922G, that says that you cannot be a user of an illegal drug and/or addicted to a narcotic as defined by certain schedules. I won't bore you with specifically, though, the Hamani case deals with whether or not 18 U.S.C. 922G3 is constitutional as applied to Mr. Hamani, who was a regular user of the illegal substance of marijuana. There's no suggestion he had a medical card or anything like that. He just a user of marijuana, which is a federal crime. And at the same time, he possessed firearm. He's going to lose that case. Mr. Hamani will lose that case, and they will find that Mr. Hmani, as a regular user of the illegal substance of marijuana, cannot challenge a conviction under 922G1 if he possesses firearms. That will be that. But what about all these other Second Amendment cases that are now pending? The Supreme Court has been looking at these cases, and they're going to look earnestly at these cases on Friday, this Friday, tomorrow, and next Friday. So what can we hope to see here, and what's going to happen? Well, let's just go through the big ticket items here. We have the assault weapon cases. The big one is the Viramontes case. This is the one that's most likely to be heard if you're going to hear an AR-15 ban case. This is the one arising from Illinois. The Viramontes case deals with a ban on AR-15s by Cook County, which is the county in which Chicago sits. That's the Viramontes case. And I think there's a good chance the Supreme Court is going to pass on this. Not because they don't want to rule in favor of the AR-15. I suspect they're waiting for the 7th Circuit and Judge Frank Easterbrook to screw up the Barnett case out there in the 7th Circuit, which the United States Department of Justice under Pam Bondi and Donald Trump stood up for and fought for our Second Amendment rights. I suspect the U.S. Supreme Court is waiting for the Barnett case next term rather than take the Viramontes case this term. That is my best guess. So I don't think they grant certain veramontes, although will be conferenced this Friday, i.e. tomorrow. Then you have the magazine cases. These are bans on large capacity magazines, which are really just standard capacity magazines that hold more than, let's say, 10 rounds. We should win these cases as well. But the two cases that are up is the Duncan case out of the Court of Appeals for the Ninth Circuit, dealing with a California ban on so-called large capacity magazines, and the Gator Custom Guns case out of the U.S. Court of Appeals for the Ninth Circuit as well. But this case arose out of a nutty decision by the Washington Supreme Court. That's right. It's technically not a Ninth Circuit decision. It's actually out of the Washington Supreme Court. Although it comes out of that sort of, left-wing coast of Washington State, Hawaii, and California. That is the Gators custom gun case. Now here's a tricky part, folks, to make you the smartest person in the room. I do not think the U.S. Supreme Court is going to grant cert in Duncan or in Gators custom guns. On the question, listen carefully, on the question of whether or not magazines that hold more than 10 rounds can be banned or not. However, I think it is possible, maybe like a 45% chance of it happening, that the U.S. Supreme Court might grant cert or Second Amendment question, and that is whether or not magazines that hold more than 10 rounds, or magazines at all, constitute arms under the plain text of the Second Amendment, i.e., the right of the people to keep and bear arms shall not be infringed. And the question is, under the plain text, i.e., what does the language mean? Question becomes, do magazines that hold more than 10 rounds and or any magazines constitute arms under the plain text of the Second Amendment? I think there is a possibility the Supreme Court could grant certain Duncan and or Gators custom guns. On that narrow question, without getting to the final question of whether or not banning these kinds of magazines violate the Second Amendment, and that would give rise to the INCOM test. But I'm pretty sure the Supreme Court wants to deal with the in common use test and the dangerous and unusual standard with the AR-15 semi-automatic rifle bank, because I think that's the easiest, cleanest case for them to do so. But that doesn't mean they're not going to rule in favor of Gators custom gun or Duncan eventually. The question is, will they deal with that plain text question this term? That is going to be a close call. Then you have a series of 922G cases. 18 U.S.C. 922G, as you know, is the prohibited person statute under federal law that says if you fall into any of those categories, you're not allowed to possess a firearm. We have a series of cases there. There's the Deard case out of the Ninth Circuit. There's the Vincent case out of the 10th Circuit. These both involve nonviolent felonies. 18 U.S.C. 922 G1. Both Darday, remember Dardy was a case that the three-judge panel in the Ninth Circuit ruled in favor of the Second Amendment send because Mr. Dardy had been convicted of multiple felonies technically under federal law, but they were all nonviolent. He could not be disarmed because you could only be disarmed if you're convicted of something that is physically violent. And nothing he did was physically violent, and therefore he could not be disarmed under the Second Amendment, notwithstanding the language of 18 U.S.C. 922 G1. Likewise, we have the Vincent case that is a Jean Valjean case. Really, you have Miss Vincent, who at this point has multiple graduate degrees and a social worker, but when she was a young lady, she had some issues. I think she may have been homeless, and she was caught trying to write a fake check for about $490. Got caught and was convicted, never sentenced to jail for a day at all. Nevertheless, she lost her gun rights forever. And her argument is that as applied to her, you cannot disarm her for life for writing a bad check when she was a young dumb kid, given the fact that she is now a graduate, has multiple graduate degrees and is a successful professional and has never been convicted of anything violent. The question is, what will the Supreme Court do on the 922G cases? Here's my best guess. I suspect they're going to hold these cases because they're going to want to see how the Department of Justice's 925 efforts go in terms of restoring the rights. I think if 12 months from now the Department of Justice has not restored the rights of tens of thousands of people, I think the Supreme Court is much more likely to take another 922G1 case dealing with nonviolent felons. But for now, I think they're going to defer to the executive branch and say to the Department of Justice, you want to process these people and restore their rights through the administrative process under the federal statute enacted by Congress, then you should do it right now, and we will hold off and give you another 12 months before we decide a nonviolent felony case. Because again, it'd be easier to solve these things administratively for the court system in its whole. I think that's probably what's going to happen with the 922G cases. They're going to be held, and they're going to wait and see what the Bondi Department of Justice does with that new restoration of rights process, which I think will be very successful once it's officially up and running. There had to be a period of time where they gave notice, and I think that period of time has come and gone. Now they can issue the regulations in their final form and start to restore the rights of individuals. Then we have now at the Supreme Court a series